Stand, please. Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-5220. Cigar Association of America et al. Versus United States Food and Drug Administration et al. Appellants. Ms. Powell for the appellants, Mr. Ebney for the appellants.
Good morning, Your Honors. May it please the court, Lindsay Powell for the government. I'd like to reserve 3 minutes for rebuttal. As part of its public health analysis, FDA expressly acknowledged in this rule that patterns of less frequent cigar use result in less risk for many users, and it explained why regulation was nevertheless warranted. And I want to be clear in what the rule says about this. So if you look at page 2920 of the Federal Register in the final rule, it says cigar smokers generally smoke at a lower frequency and tend not to inhale the smoke, thus reducing, but not eliminating, their exposure to its toxic substances. That's what plaintiffs say that the agency failed to consider. And it is right there in the rule, not just in this reference, but also others. And it's an observation made with respect to premium cigars in particular. The district court
Could you elaborate on that? How is that an observation about premium cigars? Because from what I reviewed, it seemed that there were a lot of general statements about cigar use, but there's a subset of cigars, which are premium cigars, which have an even different pattern of use, which is even less frequent.
So two things, Your Honor. One, as FDA also notes on page 2920, there is sort of some trickiness with the terminology. Premium cigars are not a widely acknowledged class of cigars. They're not defined that way. And in the scientific literature, the studies aren't broken out that way. So as FDA notes, again, at page 29.
In the Corey study, they are broken out that way.
But not in the monograph 9 study, for example. But if I may.
You would have to address the Corey study.
So the point that I was making about FDA acknowledging infrequent use with premium cigars is where it makes statements, for example, at 2920, that some premium cigar smokers might smoke such products infrequently does not negate the adverse health effects or show that cigars do not cause secondhand smoke-related disease. So the point here is this is not a rule where FDA is saying there are no patterns of infrequent use or that patterns of infrequent use don't have an effect on the resulting rate of disease.
Those statements were already in the NPRM. And nonetheless, the agency said, we would like to know about relative harm for premium cigars, your terminology, and ask for data on that and ask about the term relative to other forms of tobacco intake, and ask should some different regulatory measures be adopted. So it wasn't all or nothing, and so it was an inquiry using the premium cigar language. So we can't beg off that there's no definition on that. And looking for relative information, relative comparisons for premium cigars and other things as to health issues and to regulatory need and regulatory measures. So I don't understand how those general statements are responsive to what the FDA expressly put on the table.
So again, in terms of what data was then available in the final rule, I want to be clear about this because there are two studies that the district court and the plaintiffs say that FDA did not adequately consider. One of them is monograph 9, and that's not specific to premium cigars. That's also noted in the notice of proposed rulemaking. It's expressly acknowledged by FDA at page 2924. So again, this is not something the agency overlooked. It's right there. It's acknowledged, not specific to premium cigars. The Corey study is specific to premium cigars. And again, the agency did discuss it for the very significant point that over a third of premium cigar users also smoke cigarettes, which underscores the complexity of these tobacco use issues and the attendant public health consequences. It is true that FDA did not cite the particular Corey study finding, did not spell it out, that only about 3.5% of premium cigar smokers use these products on a daily basis. But it doesn't follow that FDA overlooked that frequency of use issue. It says, we know that these products are often used less frequently and that infrequent use entails less risk. That's the fundamental public health
There's the
point.
analysis of, which the NPRM also asked for, of what the implications of that markedly less frequent use are for appropriate regulation, and combine that with the evidence of this products not being marketed to youth. So you asked for, should there be adjustments to the regulatory regime? And then instead they were just shoved in, including all these advertising restrictions that are aimed at protecting youth that are just not relevant on the record, or haven't been shown to be relevant on this record to premium cigars.
Well, several points in response, Your Honor. One is just briefly taking a step back. This is quite broad tobacco product regulation, and premium cigars are not the only products that are used infrequently that are thought to.
What is a premium cigar?
That's a great question, Your Honor. It is not defined at federal law. It is not a clearly defined category, which is one of the reasons we're having so much trouble implementing this user fee scheme on remand. But in general, it is a larger cigar that is made solely of tobacco. There's a 7-part definition that the district court set forth for purposes of this case. But the products like hookahs and pipe tobacco are also used infrequently by many users,
There
and they're
was a
still.
definition in a notice of proposed rulemaking. Wasn't there?
What is that definition? I have that here. I don't think, apart from the administration of the user fee scheme, I don't think a lot turns on this definition, but in the notice of proposed rulemaking, it's wrapped in whole tobacco leaf, contains 100% leaf tobacco binder, contains primarily long filler tobacco, is made by combining manually the wrapper, filler, and binder, has no filter tip or non-tobacco mouthpiece, and is kept by hand, has a retail price of no less than $10 per cigar. That term is not in the district court's definition.
Inflation adjusted.
Inflation adjusted, does not have a characterizing flavor other than
The
tobacco.
$10, Judge Mehta did not put that in his definition, right?
Correct, Your Honor.
Right.
Correct.
So what about the statements about there being no data provided to support the premise that there are different patterns of use of premium cigars?
Yes, Your
There
Honor.
were like 4 different statements to that effect, but there was data. It was the Corey study.
So these statements need to be considered in context and also, I think, parsed very specifically. So there are 5 of these statements in total. 2 of them, if you look at them on their own, it does make it sound like perhaps there was no evidence in here at all about patterns of use or the effect that infrequent use has on harm. But as I've been talking about, we know that's not true because FDA says over and over again, we know that less frequent use decreases risk. We know more frequent use increases risk. That's right there. This wasn't a mystery. It wasn't a secret. It wasn't something the agency overlooked. And it also acknowledged that many cigar smokers, including premium cigar smokers, are smoking less frequently. And so you have to take these statements in that context when you're trying to figure out, did the agency actually overlook part of the problem? 3 of these statements say something a little different. They don't say there was no data about patterns of use or the harms of infrequent use. They say that there wasn't data to support the conclusion that these patterns avoid the risk of disease and addiction in premium cigar smokers. And that's a very different thing. That really gets to part of the core of this public health inquiry is what are the other risks that we're worried about? There's the risk of.
If you combine the Corey study and monograph 9, isn't that evidence that there is no public health problem with premium cigars? Or at least there's data to that effect. I'm not saying that that's true, but the Corey study says it's very, very infrequent. Only 3% do it daily, and most people do it very infrequently. And then the monograph 9 says, if you smoke 1 to 2 a day, I'm surprised this is true, there's no health impact for people who don't smoke at all. So that's data that there's no health impact based on smoking premium cigars. And the agency said there's no data.
So that's not what monograph 9 says. There is a finding based in all likelihood on the extremely small sample size that the findings of the increase in all-cause mortality were not statistically significant. That's not the same as a finding that 1 to 2 daily cigars are safe by any means. The same study also finds that
That's a good explanation, but I didn't see that in the final rule.
the same study also finds that the risk of aortic aneurysm is about doubled on that same frequency of use. And backing up to the sort of introductory statements.
No, but is all the stuff you just said, including statistically insignificant sample, was that in the final rules explanation?
It's not in the final rules explanation. And again, this is in the course of a much broader
Sure.
rulemaking where I mean, the standard that we bring to these agencies' decisions is not, an impeccable explanation of each of these points. Did it consider that less frequent use of these products might reduce risk?
So
And it
if we
did.
think that that's not adequate, a general statement that less frequent use reduces risk. If we think that based on this case, given what the NPRM said, the focus on premium cigars, that subset, if we think that that's inadequate, then you lose. Because you're relying only on the fact that general statements about cigar use and less use is adequate. If we don't agree with you, you lose, right?
No, Your Honor. So the point I've been focusing on is trying to underscore that this was not, the agency emphatically didn't overlook this question of infrequent use, but it also abundantly explained why a number of considerations in conjunction with this frequency consideration warrant regulation. And it's important to recall that the deeming rule is an on-off switch. If premium cigars are carved out from regulation, they are not subject to any of these FDA authorities, any of these provisions. You can then have, people handing out free samples and putting them in vending machines, and the federal minimum age of sale rules don't apply. It's a fundamental question about regulation.
Your NPRM asked about should there be adjustments to the regulatory scheme given if you ask for information about different risks and if shown, should there be adjustments to the regulatory scheme? Is there something in the law that would prevent the FDA from saying, just hypothetically, premium cigars, okay, they don't need to have these, you're not so worried about the marketing to youth because by definition, they're not flavored and they aren't sold in a way that's marketed to youth. But we're still concerned about health risks. And so we will have a modified regulatory regime as to them. Is there anything that would in the law that prevents the FDA from doing that?
The way Congress wrote the Tobacco Control Act, there are certain provisions that either apply or do not based on operation of the deeming decision. And again, none of them apply if they aren't deemed. So that deeming decision, which is all that's at issue here, should they be deemed, is the threshold inquiry for any of it to apply. There is then some room for FDA to make product by product considerations. But in addition to frequency here,
But it just seems to me that the things that you're saying we should be worried about probably are not really worrisome. Like nobody's handing out $10 cigars as samples. They're not selling premium cigars at a vending machine.
because it's been illegal to do so until now. If you make these products, the only products that
They're
are not
luxury
regulated.
products. You think that there are people who want to sell, some of these cigars are really expensive. Like you
People
think,
want to buy them from a vending machine?
FDA predicted that if these products are singled out from regulation, that they are the only tobacco product out there that are not regulated, that a number of things will happen. Patterns of use will change. People will get the message that these products are relatively safe, which they are not. These are inherently dangerous products. They cause laryngeal, pharyngeal, oral, esophageal, stomach cancer. They cause aneurysm. They cause heart disease.
What stops the FDA from saying, you did a whole nother ANPRM in 2018 to collect more information. I'm saying, from looking at that, either reopening this record or using that new one, however you want to do it, collecting information again, making a judgment again about regulation, dealing with the data, and making a decision that wrestles with the data that's provided and making a regulatory decision that deals with whatever bad problems emerge in this period or have emerged maybe already since the rule has been vacated. There's not, and by the way, in the process of defining premium cigar, however you all think is appropriate based on the record.
So when FDA withdrew the ANPRM from the unified agenda in 2021, it explained, based on the evidence available at that point, that its decision to regulate, that the decision to deem was amply supported by the evidence available. And it expressly
Okay, but
acknowledged.
that has now been, overturned by the district court. And so what I mean, you haven't done a new rulemaking based on that.
No, but this is reflecting FDA's thinking about the then current evidence as of 2021. So just a
Okay.
couple years ago. So this is,
Right, so go forward and make, I mean, the problem here wasn't that the district court found you lacked statutory authority to regulate premium cigars. It was a breakdown in the rulemaking process, and we have your arguments about that. I'm just assuming if those aren't accepted, you're talking about all these harms and like it's an in or out thing, but it's not permanent, is it? There's nothing that stops you from doing the rulemaking again in a way that would be consistent with what the district court's concerns were.
that's absolutely true. And if the court were to remand without vacating, it would be all the easier. This FDA absolutely can further explain this if needed, but the explanation really is there. And in addition
If you
to
remand without vacating, you can't consider the information you gathered from the 2018 process or those later judgments.
correct, but as FDA explained in 2021, the information doesn't change its view. It was aware of infrequency then, it's aware of infrequency now, but I do want
You
to.
guys can fix the problems, right? You guys can deal with this going forward. It's just a question of what the judgment is that needs to be done.
It's a question about what process would be required for it. But these, I do want to be clear that these are incredibly dangerous products. A single one of these large cigars contains the same tobacco.
Wasn't that the question you were supposed to answer? Are these dangerous products? Maybe they're not because of their patterns of use.
But FDA,
Your argument, it assumes the answer to the question you were supposed to answer that you didn't answer.
well, in the final rule though, and FDA does answer it. It explains why these are dangerous products. And so if you have a product.
But if based on the patterns of use, people use them very, very infrequently, they don't have the same dangers. That was the whole question, but that has not been answered. So I don't think you can rely on that answer and assume that it's true.
FDA acknowledged in the rule that people who use these products less are exposed to less harm. That is in there. That was part of what it considered. It doesn't cite the Corey study number, but it considered that. It also considered.
Right. But I'm just saying that I don't think you can sit here and argue relying on the fact that these are incredibly dangerous. That's too simplistic given the record here.
Well,
Do you want to move on to the
I'd like to take
vacator versus no vacator?
one more stab at this if it's okay, because this is in the final rule and it is much of what justifies FDA's decision. So it's not just them saying these are
I
dangerous.
just think it's a circular argument because the question is whether that's supported. The question is whether you took into account all the data. The question is, so I don't think you can stand on that.
There's what FDA took into account, which includes that these are the equivalent of an entire pack of cigarettes, that by the Corey study's own information, you have over 120,000 people smoking them every day, that you have secondhand smoke exposures, which are, how much smoke I'm exposed to is not affected by other people's frequency of smoking. If I'm working in an establishment where people
But
are.
everything that you're saying is not in the rule.
That is in the rule. These things are in the rule. The fact that this is equivalent to a pack a day and that.
No, but it didn't account for what's in the Corey study that you just relied on.
The one thing that is not expressly spelled out in the rule is the 3% figure.
I know, I'm just saying that you were just relying on that.
And the ancillary point.
Well, you did ask about relative harms. I think that's what Judge Pan is referencing here. And that spoke to relative harm in the final rule.
And I'm.
To get to we're over time, to get to, I think you're looking at remedy questions, and Judge Randolph had alluded to that as well. You've made arguments about the definition of premium cigar, objecting to the district court's definition, but you didn't raise that before the district court, so how could we consider it now?
We, as part of our broader objection to vacatur of the decision, explained the difficulty of implementing the definition in the context of this user fee scheme. And it was very much an open regulatory question in the final rule. It's a fairly extraordinary thing to judicially define this category of products when that definition doesn't come
He
from.
used an FDA definition.
From another context and not the one in the proposed rule. And it's
Would have been a great argument to present to the district court. I'm just trying to struggle with the rationale for us being able to entertain that argument. I understand the concerns about it. He didn't pick the one from the NPRM. I don't know why. But it's it's your wheelhouse to define, one would think, but he wasn't overreaching in the sense that he made up his own. He picked an FDA definition and got no objections on that ground from the FDA. So I'm just not sure what we can do about it at this stage.
There are the broader concerns about vacatur
Okay.
with any of these definitions. I mean, this is a zero-sum user fee scheme that is proving extremely hard to administer and untangle the definitions that Congress provided when it expressly contemplated that cigars, including all cigars, there's no carve out for premium cigars. Again, that's not something defined at federal law, that it would be tied to excise tax data it can't be parsed this way. And so FDA now has over 175 pending fee disputes that it has to consider individually. And so this, if you look
Maybe
at
a good reason to hurry up and do your rulemaking on premium cigars.
Indeed, the rule was only vacated a year ago. The clock has not been ticking for all that long. And again, we do think it was not a fair characterization of the rulemaking to say that FDA
So
didn't consider.
We're reviewing for abuse of discretion, and vacator is the default remedy. And the other side says that there are no precedents reversing a district court for granting this default remedy of vacator. Are you aware of any precedents where we reversed under
No.
those circumstances?
No, but it clearly is an option. If you look at Standing Rock, for example, when the court.
It's an option, but it's an abuse of discretion standard. So even if both options are reasonable, we can't reverse them if this one is.
Sorry, I mean that under the abuse of discretion standard, it is an option to conclude that it was an abuse of discretion. It's not the fact.
Of course it is.
Yes, so that I am not aware of an example, but the way the court engages the analysis, it is certainly available for the court to find that. And this is the quintessential case where a number of things make clear that FDA would reach the same conclusion if given the opportunity to explain more. There are all sorts of other products that in one way or another present less
Why is
risk.
it clear, given that there's ongoing rulemaking going on to examine this issue? Why is it clear that
There is
use the same-
there is an ongoing rulemaking. The FDA has withdrawn the ANPRM from the regulatory notice. It's not ongoing. It has said that the current evidence supports the decision made, but there's also this broader context where you have e-cigarettes that present less risk, that may present a public health benefit. You have hookahs that are used less frequently. You have pipe tobacco used less frequently, and FDA deemed them all. It is clear that in this broader public health inquiry, which absolutely applies to cigars, it's not just a question, does less frequent use decrease risk? There can be decreased risk and still an ample basis for regulation, and FDA explained that ample basis here, where it explained in very specific ways the harms of these products, the way premium cigar users, again, over a third of them, are also smoking cigarettes, which dramatically increases their risk of harm and demonstrates the complexity of this issue. People are misled about the safety of cigars.
Any of these folks, no one's asking for refunds past fees paid, correct? This is all prospective?
That's unclear. That's unclear whether
I
they
mean,
will
you said
be.
you've got these disputes. Has anyone asked for refunds?
So the disputes have to do with figuring out these,
Has
what's
anyone
owed.
asked for refunds?
Essentially, yes. What we haven't gotten into is whether past year refunds would be on the table. So,
That's what I meant.
yeah, so with the current disputes, that is absolutely, they are asking, their FDA sends in the quarterly amount and they say, we don't think we owe this amount. And so then there's a dispute about what amount
They
they should
pay it
have to
under
pay.
protest.
Or withholding the amount while it's being considered case by case.
That's very different from, what I'm trying to ask is anyone asking for a refund of fees that were paid before the district court's vacatur order?
They have not, but I'm not sure that's a closed question. I'm not sure whether,
I assume the FDA's position would be.
well, yes.
Closed, because that would be a very different type of district court order if the vacatur were read to do that. That would be something very different. One could certainly ask the district court for clarification, I suppose, but that would be an extraordinary exercise of the district court's power that our precedent has said would be cutting, or could very well be cutting into abuse of discretion land. So we shouldn't read it to do that.
I agree, Your Honor. It is just not entirely clear to me how others might read it.
Questions? Great, thank you very much. We'll give you some time for rebuttal. That's good.
Thank you, Your Honors. May it please the court. My name is Michael Edney, and I'm here on behalf of the premium cigar manufacturers, retailers, and consumers. Judge made it correctly held that the FDA's decision to regulate premium cigars was arbitrary and capricious. And I want to jump directly into the questions that the court was asking of opposing counsel in this matter. The issue here is a finding regarding the specific differences between premium cigars and other cigars. And that's something that is entirely absent from the final rule. And to the extent it was made erroneously. There are two key conclusions on this point. One's at 29,020, and this is the conclusion that there was no data presented of different patterns of use of premium cigars, and that those patterns result in lower health risks. And the next one's at 29,022. That's where the FDA.
One at a time. So on that one, they backed up that there's not lower health risks, maybe different health risks, but it's not lower. They backed that up. They said the data shows that there are these risks. They still have terrible risks of cancer in the mouth and laryngeal, or maybe less in the lungs. But so that part of it was addressed in the final.
No, Your Honor, I don't believe that's right. The FDA at that passage at 29,022 is.
Sorry, I thought you said 020.
020, I'm sorry, is having a discussion regarding the surgeon, and this also happens at 022, is having the discussion regarding the Surgeon General's report. And the Surgeon General is saying, look, cigars have lesser health effects than cigarettes because they're smoked less frequently and there's some suggestion of lack of inhalation. That's a comparison.
They're not generally inhaled.
That's right.
Well, on 29,020, they say there's no data as discussed in section, sorry, is that 7C?
That's right.
So 7C lays it out more and gives all the context to that no data statement.
Right. I think it does. And then I would direct the court to 29,022. This is the next specific statement on this.
Well, there's one more in that same column, which I think was the other one you referenced, which doesn't have the cross-reference to 7C. Moreover, there were no data provided to support the premise that there are different patterns of use and that these patterns result in lower health risks.
That's right.
And I was just responding to the second half of that they result in lower health risks.
Right.
They addressed that and said, here's what our data shows about the health risks of these.
Well,
So it's really only the patterns of use part that.
but this addressing that's going on regards the difference between cigars and cigarettes, not between regular cigars and premium cigars. And I think the key context is at 29,000.
Why did they, their NPRM is saying, look, here's the things we're already regulating. This is cigars being the big, or cigarettes being the big one. And we're interested in knowing about how these risks compare to things that we are already regulating. Not just to cigars, to the health risks of things that we are already regulating. So it seems perfectly legitimate in section 7C to have made those types of comparisons. And we don't fly spec agency explanations, right? They've said, look, here's why we're going with option one, danger, 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 harmful, harmful, harmful. And the data that they talk about, and they talk about a lot of data, not the stuff that you want them to do, but they talk about a lot of data and a lot of studies and say, the health risk is still substantial and warrants regulation. And so why is it why isn't that those explanations for why we're going with option one do not implicitly answer the question of why we're not going with option two?
I would put it in a different way. If we go back to the proposed rule, there were premises of the proposed rule that were beyond dispute. We are going to regulate cigars, most cigars, right? That nobody was contending to the contrary.
There's no challenges to that.
There was no challenges to that. There were really no commenters asking mass-produced cigars to be excluded from regulation. That wasn't on the table at all. This is the FDA that set up this option 2. Option 2 was we're going to define the category of premium cigars because perhaps they're used in different ways, and those different ways have lower health risks than other cigars, not in cigarettes, than other cigars.
Well, they want to know if they have lower health.
That's right.
They
That's right.
define that they do.
And then when we get to the final rule, what the FDA is saying is, look, cigars in general have health risks. That's what we knew when we proposed a rule. We gave all these participants in the marketplace an opportunity to come to us with some real hard data about the specific patterns of use of premium cigars. And then they say, nobody showed up, right? Nobody showed up with premium cigar specific data. It's just one big giant ball here. And I think that's where the FDA really drives it home at 29,022.
When you read the final rule, what they're saying is, here's a bunch of data that shows there are still material health risks, significant health risks, even with premium cigars that warrant regulation.
Your Honor, I think the reason why they reached that conclusion is because of what they said at 29,022, is that we asked commenters to come up with premium cigar specific data regarding their patterns of use. And no such data was presented that showed that they had lower health risks. What they're saying is what we got was a bunch of assertions about how premium cigars were
What they're saying
used.
is we found no lower health risk. It's a different health risk. It may show up in different parts of the body, but there's still health risk there from smoking cigars. It may not be the all mortality one, but it is mouth, laryngeal, esophageal cancers.
The FDA found health risks with regard to cigars in general, and they found it in the proposed rule, and it was really beyond dispute, and in the final rule, when they explained why they were finding no lower health risks with regard to premium cigars, and therefore no need to explore the situation of whether a different regulatory scheme is appropriate for them. They said that there was no data presented that premium cigars have different patterns of use that result in lower health effects. What they were saying is, look, all we got is a bunch of studies about cigars, and we didn't get anything serious about premium cigars. That is not true, though. The record did have an FDA-sponsored
Not quite what they said, and they did talk about it. I guess what I'm trying to ask is which study showed that they were wrong to think that there are risks. It may be a small portion of the population, but there are still substantial risks of cigar-specific cancers for premium cigars.
The FDA never made that conclusion specifically with regard to premium cigars because it said the reason for its conclusion regarding premium cigars that there was no data presented of different patterns of use between premium cigars and other cigars and the attendant lower health risks of those different patterns.
I mean, everything turns on the health risk. It's not, they wouldn't care about the pattern of use unless the pattern of use reduced health risk or marketing to children, which I don't think they dispute is not an issue.
The notice of proposed rulemaking recognized that all cigar smoking is potentially harmful. And I thought the rulemaking was to determine whether there was a significant difference in the harm between regular cigars and premium cigars. And the FDA said, we have no data on it. But in fact, they did.
That's exactly right, Your Honor. I think we need, and I think Judge Mehta explained this very well, we need to consider the final rule in the context of what was said in the proposed rule.
I understand that, but what I'm trying to, and if I've just missed this in the record, please tell me. I recall the evidence that was submitted about all mortality risk for premium cigars being, I think there was no difference for the norm of premium cigar users, the ones who don't use it regularly, as to all mortality risk as compared to non-smokers. Is that correct? Am I remembering that correctly? As to all mortality risk, premium cigars, the vast majority, the 97% who use it infrequently, There is no increase in all mortality risk, correct?
So the evidence in the record under monograph 9 is for those who use 2 or fewer cigars per day, there's no evidence of a statistically significant increase in all mortality risk.
Okay,
That's
but
correct.
now that's all mortality risk. But what they cite in the final rule is specific types of cancer that cigars are, that cigars have a particularly increased prospect of causing. Was there a study that you guys submitted that said that may be for your run-of-the-mill cigars, but premium cigars do not cause those cancers, or have a, not do not, that would be, might be too hard to show, but are not associated with that higher risk of those specific mouth, esophageal, whatever other parts of the bodies are here, sort of the above, neck and above cancers.
Your Honor, I think what you see in the proposed and the final rule where it discusses monograph 9 and other studies is that cigars in general can cause these other cancers. What you don't see anything of.
I'm asking you this, what your clients or others put in to show that premium cigars are different than regular cigars when it comes to those specific forms of cancer, not all mortality risk.
And what we put in is at JA 529, this is the Cigar Rights of America comment that says, look, when you look at premium cigars, our consumers, especially in particular, 97% of them are using the product less than daily. And remember, the threshold for all-cause mortality is fewer than 2 cigars per day. So even the smaller.
2 or fewer.
2 or fewer, that's right.
Yeah.
2 or fewer, Your Honor, exactly right.
Okay, so this might be my confusion.
Yes.
Okay.
Oh, okay.
As to what all-cause mortality means. I had thought all-cause mortality was all tobacco-related mortality. But then within that would be a subset of the particular cancers, a submortality set of the particular cancers associated with cigars. And that's what my question is about. I give you that you guys put in the information, or somebody put in the information about the comparison of all mortality risk. I'm asking about this subset of cigar peculiar cancers, whether mortal or quite disabling.
All right. And to answer that question, yeah, I will direct the court to Judge Maida's answer to that question at J 26 through 28, and I'll try to reprovide that answer myself. What we're getting confused about here a little bit is that
I'm getting confused.
No, you're not. No. It is confusing, right? And I think that's one of the problems with the final rule. It shouldn't be confusing. We should have a clear explanation. But what opposing counsel said below is, hey, listen, even with regard to this cohort of people that use 2 or fewer cigars per day, it's not just all-cause mortality. There's these other bad things that can happen even to them. They have slightly elevated risks, right? That analysis is absolutely nowhere in the final rule, nowhere, right? And I think Judge Maida marched through this and said that's a convenient post hoc explanation about saying, premium cigar consumers, 97% of them at least.
Was there, I'm asking, was there evidence in the record that showed that as to those concerns that are definitely flagged in the final rule for cigars, as to premium cigars, there's evidence they do not contribute or do not contribute at the same level as other cigars or other tobacco products to those specific cancers? That's the narrow question I'm asking.
Your Honor, we need to take the FDA seriously in what they said.
No, I'm asking you what you all said to know whether they ignored. I'm asking whether they ignored that particular information, or your concern on health risks is that they ignored the study about all mortality risks.
Yes, they ignored that, and they did not say that. What they didn't say is for these infrequent users, whatever increased risks there are of these other health side effects, those are important enough and significant enough to justify this massive regulatory scheme. They didn't say that. right? What they said in the final rule was cigars cause these other types of health effects. But what they didn't analyze, what the FDA didn't analyze in the final rule is for these 2 and fewer cigar per day folks, is the increase of these other health effects, is that enough to justify the regulation? And that's an analysis that came post hoc in the district court.
That's just that's not ignoring data. That's just a gap in explanation. What you're talking about now is they didn't make that separate sentence. That's not what Judge Mehta was relying on at all.
Well, no, I think
That's not those no data.
No, I think he was relying on the lack of that explanation, but I think he was.
I read it, his decision, and certainly his vacature decision was very much based on, and what you all were pressing hard, and I understand why, were these no data comments, not just one gap in, they could easily be discerned from the final rule. They just didn't spell out one more sentence that here's this terrible risk from cigars, here's the terrible health consequences, and it is bad enough and without evidence that premium cigars are different as to those specific cancers. They might be better for all mortality, but not as to those specific cancers. We don't think we can take them out of the final regulation. That's an ordinary sort of fill-in gap issue in agency explanations that would not warrant the type of response we got from Judge Mehta here.
Your Honor, what Judge Mehta held, I believe, is that the FDA told us what it was doing. It said we have all these concerns about cigars. We had them in the proposed rule. We gave people an opportunity to come up with premium cigar specific evidence, and they flubbed that opportunity. They didn't provide us any studies regarding the health risks specific to premium cigars, and we did. We provided a study that they didn't deal with that specifically determined that premium cigars are smoked by those who use them. 97% of them smoke fewer than one per day. That's far away from some of the most serious health consequences. And remember, the proposed rule.
What percentage of the adult population smokes premium cigars?
I believe the studies say somewhere around 11% of the adult population smoke them at all, right? So it's
Smoke
any premium cigars, correct?
And as
cigars
far
more
as
generally is a little bit higher.
minors are concerned?
The evidence in the record is that number is statistically indistinguishable from zero, right? So
1/10 of 1% smoke any cigars. Right?
no, smoke any premium cigars. So what the FDA cobbled together this.
These got to be rich kids. I mean,
Yeah, well, I guess they're out there, right? I wasn't, but the.
Thing on the remedy, because I don't want to hold you up on time.
We have as much time as the court needs.
You don't read the district court's order as authorizing retroactive refunds of user fees paid. There's fights about refunds since the date of the vacature order, but we have said that vacature may very well be inappropriate if it's going to take money out of the government's pocket. Or do you read it that way?
Well, Judge Mehta correctly held that in 2016, the FDA acted illegally when regulating premium cigars. The
I'm aware of that. I'm trying to get an answer
Yeah.
to my question about refunds from the date from prior to 2023, when the rule was vacated.
I think that the logical consequence of the vacator ruling is that the regulation of premium cigars was improper from the beginning, and refunds
Yeah.
would be potentially appropriate.
Has anybody asked for refunds?
Not to my knowledge, Your Honor.
They sure will now that you've said they can, or that their
I know
counsel is
that.
telling them that that's available.
Nobody follows my
That's a
advice all the time. but-
How much money are we talking about if there were to be refunds?
Almost nothing, Judge. So if you look at section
Okay, I think
919.
your government definition of almost nothing and my almost nothing were probably very different numbers.
Well,
We're talking
no, we have to look in orders of magnitude. So if you look at section
Are we
919 of the
talking
act,
millions of dollars?
we are talking millions of dollars, but on a relative basis.
How many?
The evidence in the record is that premium cigar manufacturers are paying $15 to $20 million a year in user fees. That's of $712 million as of last year. So annually, the FDA is bringing in.
Okay, that's not almost nothing in my view.
But it is 2.5% of the annual user
That's a
fees.
very different thing, but I don't see anywhere in Judge Meadows' vacature analysis, the type of analysis that we would expect and our precedent requires if a court is entering an order that allows retroactive payments of money out of the U.S. Treasury. Can you point me where he analyzed that aspect?
He did not analyze it, and it was not before him.
So it
That's
wasn't
exactly
argued.
right.
Okay.
That's right. It was not before him. The issue wasn't ripe.
Oh, it's not a
So,
question of ripeness. It's very ripe. If in fact, that's the effect of his vacature order, it was very ripe.
well,
Forfeiture, I think.
Your Honor, I'm pretty sure, and I may be wrong about this, and I don't want to go too far down this road but I don't think I could have asked Judge Maida for a refund. I think that jurisdiction is probably down the street at the Court of Federal Claims if anybody wanted to bring those under the Tucker Act and other revenue related.
I'm not asking whether you can ask him whether his vacature order had that effect, and he did not analyze it as having that effect. He hadn't analyzed it as sort of a purely prospective vacature.
Exactly, and the issue wasn't presented. That the issue at that time was what should be the remedy? Should it be vacature or remand without
He was dealing with
vacature?
a payment scheme, and he talked about the user fee scheme.
That's right, and he talked about the burden of having for premium cigars manufacturers effectively having to pay for the regulation of other products. And I think this is an important point, Judge. We're in a situation here where litigation counsel for the FDA is arguing that obviously the FDA, if it had mentioned the study, it would have come out in the same place. But there's a huge divorce here between what litigation counsel is arguing and the FDA policymakers. In a formal release, and you can find this at A41, they came out and said, look, we need more information on these patterns of use and the type of information that would be really
It's
important.
outside this record.
Well, it is,
Okay.
but it isn't, because,
It is or isn't. It was after the rulemaking record closed,
well,
correct? It was after the rulemaking record.
that's
closed.
correct.
All right.
But Judge Millett, opposing counsel is asking this court to kind of supply missing reasoning in the final rule, okay? And I don't think this court should do that at
I don't
all.
think they're doing that at all. I think they're saying, if this is just the dispute between you, they think we gave enough reasoning, and you say they didn't, and Judge
Well-
agreed with you.
So can I ask, it seems to me that in reviewing what the agency did, we can only look at what was in the record. But can we, when we're looking at whether vacator was appropriate or not, and we're thinking, is the agency going to just do what it did before? 'Cause that's a factor in whether or not you vacate or not. Can we consider the fact that, well, they've shown that they've had some second thoughts about this. They did go back and start re-looking at this data. They ultimately withdrew that. But is that something we can consider in evaluating whether the district court abused its discretion in ordering a vacator?
Absolutely, Your Honor. Chenery, I don't think applies to the selection of the remedy. And there is this Allied Signal and its progeny is asking for this predictive judgment. It would, is the agency just going to spack all this up and come out with the same result? The record shows that is absolutely not a foregone conclusion or really very much in the cards. And, again, I think that we should proceed on just the final rule record. But if we're going back and trying to supply reasoning for the FDA about what we kind of thought they were thinking, this certainly indicates that the Corey study and that type of data about different patterns of use with regard to frequency is super important to the FDA and may have counseled a different result. And it has led to a cascade of consequences. They've designated these products as their lowest priority for enforcement. I think you can look at JA 638. This is in the supplemental appendix. The definition for that lowest category enforcement that Judge Maida adopted, that's right out of the FDA. The FDA came up with that at JA 638.
Are there,
On-
colleagues have any more questions? All right, you had a sentence, sounds like you have a sentence.
Yeah,
One sentence.
Just one more. If you look at that same site at JA 638, what the FDA said is that at this point, the data submitted both before and against regulation is insufficient to really make a determination with regard to what we should do with these products. So I don't think that this court should be straining to save the FDA final rule explanation, where I don't think the FDA itself is committed to it. and they didn't supply the key reasoning that they have identified later, key reasoning that they identified in the proposed rule is important.
Thank you very much, Council.
Thank you, Your Honor.
All right. Ms. Powell, we'll give you 3 minutes.
Thank you, Your Honors. If the question is, did FDA overlook key evidence about premium cigar use in particular, there is exactly one piece of evidence that plaintiffs point to that FDA did not expressly cite in the rule for the proposition for which they offer it, which is the Corey study. Only about 3.5% of premium cigar users are smoking on a daily basis. They did cite the Corey study. They did acknowledge that
But not for the relevant point.
not for that statement that they say it needed to be cited for is, again, the sentiment is expressed in the rule more generally, and it appears 2 sentences before the point that FDA does cite it for in the context of this 4-page study. I mean, there's no credible suggestion that FDA didn't know about this. This is a study undertaken by an FDA scientist that the agency is citing. And if you look at the broader context, there can be no real question that consideration of that one piece of data, if FDA had spelled out in this final rule, okay, so the precise number we have on hand about just how infrequent this use is that only about 3.5% of these people are smoking daily. That's, again, still means that we have well over 100,000 smoking these, cigarette pack size products every single day.
But
what-
isn't it incumbent on the agency then to say, despite the lower use for premium cigars, we still think that it has an impact on health because, and there's nothing like that in here.
I think it is abundantly clear that spelling that out more would not have changed the outcome here. And there are many data points supporting that, both with respect to.
I'm not saying change the outcome, I'm saying you had to support the outcome with reasoning.
Well, but this is subject to a harmless error inquiry. If the error, if there was one, was not prejudicial, then it doesn't get set aside under the plain terms of the APA. But we, of course, don't think that there was error. FDA explained why, notwithstanding infrequent use, there are abundant health harms that warrant regulation. And that's consistent with what it did in the broader rulemaking. So again, this is not the only product where there's a question of lesser risk. You have infrequent use of pipes and hookahs. Those are deemed. Those are uncontroversially deemed. You have e-cigarettes, which are not used less frequently, but may present lesser risks in a significant way, unlike premium cigars.
So
Which-
I know it's not in the record that was before the agency, but it is your lowest priority enforcement. It's unlike e-cigarettes and hookahs.
The document that they're referring to is a specific set of enforcement priorities in the context of the e-cigarette vaping epidemic that was addressing how to target issues of youth use of tobacco products. And so it is true and not inconsistent with anything in the rule that children are not overwhelmingly using these products in the way they use bubblegum flavored
Can I
e-cigarettes.
just ask you too, in terms of the question of vacator, you forfeited the argument that the district court should have considered the fact that industry could ask for refunds of fees already paid, because you never raised that before. Is that correct?
I am not aware of either side specifically spelling out the vision for the availability of refunds, but certainly the complexity of this scheme and the echoes of the schemes in Allied Signal and American Great Lakes, where you are talking about the various ways in which among users, both before and not before the court, you might have to reallocate or untangle or potentially refund. Those are absolutely the types of concerns that were raised and that the government offered as a basis for needing to remand without vacatur. So you put these two things together, it is clear that FDA would have reached the same conclusion if it had considered that one item from the Corey study. This is not failure to consider an entire aspect of the question. It is a minor explanatory point. And if I can point you to page 18 of our brief.
I mean, I don't want to belabor this, but it didn't the agency thereafter say, we are reconsidering this? I know you withdrew it, but based on information like in the Corey study.
So, and that's exactly what I wanted to talk about. So at page 18 of our reply brief, we talk about what happens after the ANPRM. In the advance notice itself, the characterization that plaintiffs offer is not correct. FDA did not say, oh, there's a new Corey study with the same data. We didn't realize this was there before, and it's very important. It cited that study as an example of a study published after the deeming rule was promulgated as new evidence in the sense of subsequently published. That's the extent of what it said about that Corey study. But it says here in 2021, in withdrawing the notice from the unified agenda, even if there is significant occasional use of premium cigars, some premium cigar smokers have frequent use with significant exposure to harmful constituents that are known to increase the risk of oral, esophageal, laryngeal, and lung cancer, among other negative health consequences. Dual use of premium cigars with other tobacco products is also a significant concern, and that the evidence before the agency at that point, which is really not different from the evidence before the agency in the final rule, supports regulation. Everything points to the fact that the agency, if required to explain more to address this Corey finding more specifically, would reach the same conclusion. And again, considering it in the broader deeming context, the importance of this threshold decision to whether these products are subject to federal regulation under the scheme at all, and the way it's treated e-cigarettes and pipes and hookahs, this is a basic public health question that FDA amply answered, describing the various and interrelated harms of using this category and this particular subcategory of tobacco products.
Great. Thank you very much, counsel. The case is submitted.
Thanks. No, I'm just gonna...
Thank
Two. One. More water. Yeah, this is perfect.
Case number 20-1317 et al. Sierra Club et al. Petitioners versus United States Department of Transportation et al. Mr. Marshall for the environmental petitioners, Mr. Lusignan for the state petitioners, Mr. Renshi for the petitioner Puyallup Tribe of Indians, Ms. Jaffe for the respondents.
Good morning, Your Honors. May it please the court. Bradley Marshall on behalf of environmental petitioners. I'd like to reserve 3 minutes for rebuttal. This is a petition for review of a final rule approving the transportation of liquefied natural gas by rail. There are 2 main issues I'd like to address today that merit vacating the LNG by rail rule. First, the lack of opportunity for notice and comment on the new tank car design in the final LNG rule in violation of the Administrative Procedure Act. And second, the inadequate consideration of safety in the final LNG rule in violation of the Administrative Procedures Act and the Hazardous Materials Transportation Act. First, the lack of opportunity for public comment. Throughout the proposed LNG rule, PHMSA emphasized the opportunity to comment on possible operational controls, even though such controls were not proposed, but ultimately did make their way into the final rule. Environmental petitioners, of course, take no issue with that from a notice and comment perspective. At the same time, PHMSA specifically rejected the possibility of considering an alternative tank car design as requiring additional study.
They
Then,
required one particular
correct.
form, but they have a whole section asking for information about tank car design, and tank car specifications. They had 2 things they were clearly asking about. Subsection A, 3A is tank car specification, and 3B is operational controls. So they were looking for both.
With respect to Your Honor, if you look at that section, it specifically talks about the tank car design of the DOT 113 C
Okay,
120.
but so it wasn't just an operational controls. They were asking about tank car specifications. They referenced that particular one. But the way you've argued it is that the only thing they wanted information on was operational controls, but the NPRM talks about both. People commented about both, including your clients. So so to the extent you're arguing that we knew about operational controls, we didn't know the tank car specifications were on the table, that just, it seems hard to reconcile with the text of the NPRM and the responses to it.
We didn't know that possibly altering the tank car specifications were on the table. Throughout the proposed rulemaking, PHMSA emphasized the existing tank car and the existing operational and safety history of the existing tank car. At no point was there even any hint that they were considering modifying or proposing a new type of tank car design.
It talks about tank car specifications. NTSB and others talked about all forms of tank car specifications, including thickness of the hull. And so, and the agency responded to it. And so I'm having trouble understanding how there wasn't notice. They said, we want both these things.
We want to consider, you know, the DOT 113, the suitability of the existing tank car. If you look at the proposed regulatory impact assessment,
Well,
for
why
example.
isn't it, someone says, I want to know, tell me about the suitability of this car. And you go, not suitable. I've got to get 12 people in. I need a minivan. Right? That's a response. They say, tell me if this car is suitable. And you go, it's not, you need this. That's a common response, is it not?
Well, it would be if they said, there's as another option, here's the minivan, let us.
The other, really, if I said to you, hey, I think this, for your family of 12, I think this compact car here would be great for you. Here's its fuel efficiency. What do you think? And you would say, that's not going to work for us.
Right, Your Honor, and that's what we said.
You wouldn't say that. You'd say, I need something bigger, would be the first thing you would say. I just don't understand why it seems illogical to think that they were tying everyone, they're muting everybody to even mention things that could do to make even this car or another car stronger. You know, tank car specifications means we want to talk about tank car specifications.
That is not how they worded it. That is not how they invited comment.
So even if it's a logical outlook because tank car design was on the table, isn't it arbitrary and capricious to say that this solves all our problems? Let's just go to 9/16 of an inch thickness, and that's going to address the fireballs and the vapor clouds and all that stuff.
Absolutely, Your Honor. And in addition to that, there's attendant higher weight issues that no one had the opportunity to comment on because this tank car that they've designed wasn't in anyone's imagination. And they didn't put it out there that imagine a new tank car for us and design what you think would be a safe tank car.
But
They said
there were tank cars with 9/16 of an inch thickness because there's something in the record about, you know, a quarter of them still punctured upon derailment.
Correct, Your Honor.
So there were some of these 9/16.
Not of the double hull DOT 113 that we're talking about. You're talking about a different kind of tank car that did have the attendant higher thickness to show what would the outer shell, you know, what could that look like? And so that is in the record. And yes, of course, still breached at a significantly lower
So like
speed.
a double walled one?
That was not a double walled one.
Oh, I see. So there is no data about whether that would puncture on a derail, the newly designed? tank?
Correct. There was no data. I mean, this is a new tank car that had never been designed before, never been created before, and there was no notice that they were thinking about creating a new tank car. In the proposed regulatory impact assessment,
They were acting within the realm. I mean, the question is logical outgrowth or not.
Correct.
Right?
Yes.
And they were dealing within the realm of tank car specifications, increasing hull thickness is on the table. That's an ordinary thing. It's not like they said, okay, let's try a flying car that doesn't exist, right? They said, here's something that, you know, is routinely done to increase safety. And we're already gonna have the double tank system here, which has safety protections. We're going to maximize it because there's lots of concerns. We hear you about the safety issues, and here's how we're going to respond to it. I mean, I'm worried about the world in which, maybe this will set it up for you. whenever we write opinions like this, we have to worry about a world in which we create perverse incentives, where the agency, if it listens to comments and changes something, gets charged with that we hadn't thought about that, you changed something. The whole point of notice and comment is for the agency to learn and to respond to and react to and maybe incorporate some really well-made suggestions. And so was it out of the realm? Would people not have thought to talk about hull thickness? And your own comments mentioned hull thickness.
Of course, but no one suggested a new tank car design because they didn't realize it was within the realm of possibility. To go back to the car analogy, right? We're presented with a car, trying to, fit 12 people in.
Mm-hmm.
And instead of, we're not given a minivan, we're given a completely new car that no one's ever been imagined before. So how could people comment on that and actually have those thoughts thoughtfully considered?
An increase in hull thickness is not something that hasn't happened before. That has happened before. It hasn't been in this particular format. Okay. But it's not like they were making up something new. Increasing hull thickness is a standardized way of increasing safety and reducing puncture risk. And so they said, okay, we will add that in. NTSB said you should do that. Okay, we will add that in. We'll give it a new number now because it's different than the ones that don't have the increased thickness. But they weren't coming up with something that hadn't already been used to reduce puncture risk.
In this context of certainly the double hull of the DOT 113 tank car, it was new. It had not been done before, and it has.
Like I said, we're going to have here's two protections that already exist out there: increased hull thickness and the double car. That existed, and increased hull thickness existed. And they said, fine, we're going to do both, belt and suspenders. That's not out of the realm of a conception for someone to suggest, for people to comment on.
But they didn't suggest to comment on
Let
it.
me ask you a
No,
hypothetical.
I'm sorry, for commenters to respond to.
Along these lines, what if the agency had said, we're going to go to a triple layer? Would that be a logical outgrowth? Because they've already done a double outgrowth.
I don't believe it would be.
doubling.
I don't believe it would be a logical outgrowth because any change in the physical tank car itself, we believe would not be a logical outgrowth given what they proposed.
Any change?
Based on what they said in the NPRM, how they were going to consider operational controls and that people
That's
should
not
therefore
what they
comment
said.
on it.
I guess I'm trying to get at some point, even if it's along the same lines of what we've done before, if it's something so novel, does it cease to become a logical outgrowth? Like what if they said, we're going to have 1/2 inch thickness on the wall, on the outer shell? Is that a logical outgrowth if that's never been done before? Nobody's ever imagined that happening. What if they said we're going to have a 1 inch wall? We're going to have 4 layers instead of 2? Like at some point, is it not a logical outgrowth, even if it's loosely based on something we've done before?
Right, and especially if they invited comment on saying we're going to consider modifications to the tank car, let us know what you think should be considered. We wouldn't be having this discussion about logical outgrowth. In the proposed regulatory impact assessment,
What is your test in response to Judge Pan's question?
whether commenters.
Wait, can I pick what I want the test for?
Sure.
What is your test for when a change in a proposal is so materially different as to violate the logical outgrowth? I heard you say a couple minutes ago, any change. Is that your position?
Well, no, it's when it's a change that commenters couldn't have divined that the agency was contemplating.
What is your test for couldn't have divined? Because you know what? There were lots of comments in here about increasing hull thickness. So lots of commenters could divine that was something they wanted to suggest, including your own clients. So let me try this again. So if we don't have that, so like I said, it's not the flying car, it's something completely out of people's conception. What is a legal test that we could write in an opinion ruling for you that would say, here's how we know that this was too novel, too far out of the realm of engineering capacities or common understandings of engineering options for tank car design to be on the table for anyone to know to comment about? What is the test?
When you do an NPRM that says, this is the existing design we're relying on, and we are rejecting an alternative design, but we are going to invite comment on operational controls and consider them. And this is a deregulatory action that with no additional costs, however, we will consider operational controls. So please comment on that
Okay, so
and
when they
those
say
costs.
In the NPRM, PIMSA and FRA must consider requirements for both the packaging, i.e. the rail tank car, and operational controls. That didn't put anybody on notice that they were considering both the tank car design and operational controls. That's not sufficient.
No, especially when they specifically reject another tank car design.
Another one, but they gave a reason for that. It was
They did.
a different engineering reason.
Yes.
So why did your client and the other clients of the other two attorneys here submit comments about the tank car design?
We challenged the adequacy of it and the safety history. I mean, this is a tank car that, you know, there's been 67 of them. 3 of them were in a derailment.
You challenged it and DOT responded by changing.
Right, but they changed in a way
Why
that,
isn't that the
that
end of your argument?
if they change it in a way that commenters could have predicted, I think that is the end of the argument. Our argument is that commenters couldn't have predicted that they were going to come up with a new tank car design when they didn't put that on the table.
Even though you commented about hull thickness.
Regarding the existing tank car, because that's what they said
Right,
they
but
were relying
its hull wasn't thick enough.
on. Among other things, yes.
Okay, but okay, so you said this won't work, your hull's not thick enough, and we want to adopt a rule that says the agency can't say, good idea, good suggestion, we're going to increase it. That's the rule you want us to adopt.
No,
I
if the,
think that's exactly what your position is.
I think our position is that the agency invites comments on and says we're open to having a new tank car, then we wouldn't be having this issue.
So if the DO, we've been around the block on NEPA cases for decades. And so if DOT did not respond to your comments and the comments of the tribe and the comments of the state, you'd be here saying that NEPA their assessment is should be set aside because they didn't respond to comments.
Well, there's a way to.
It's a nice little trap you have there.
I respectfully would disagree with that, is that they can respond to comments and say we've considered what you said about the existing tank car design.
Can't change anything.
It seems to me that you had an opportunity to comment on thicknesses of the outer wall or the inner wall, but what you didn't have an opportunity to comment on is the adequacy of a 9/16 inch outer wall.
Correct, Your Honor. Nor did we have an opportunity to comment on the weight of it.
But that to me maybe is not a logical outgrowth issue as much as an arbitrary and capricious argument that the agency adopted this outer wall, which you could have commented on. You could comment on thickness, but they took the next step of saying, and this addresses all of the safety concerns that have been raised here, and nobody had an opportunity to comment on the adequacy of this new outer wall to address the safety concerns.
Correct, Your Honor. There was never a look at, what
Not
is.
the argument you've made here, though. You've made a logical outgrowth argument.
But you made an arbitrary and capricious argument.
We've done both.
Yeah.
Yes, I mean, I think, there's two sides of it. One is logical outgrowth. The other is arbitrary capricious on the safety aspects. I mean, there's been no hint anywhere that these tank cars can survive a 50-mile-per-hour derailment.
Anywhere? I mean, they did studies.
And they all derail and they all breach. I mean,
They didn't.
And they're
No.
not about these tank cars.
I mean, not about these
Never
tank
been-
cars specifically, because these tank cars didn't exist. They're a new tank car design. So there couldn't be a study of how.
Well, if ones that aren't as thick didn't puncture, then the additional thickness isn't going to increase the risk. Is there any argument that the additional thickness increases the risk of puncture?
No, although I think there is an argument on the weight issue.
I know, but they
Okay.
definitely dealt with the weight issue in their test.
But they did puncture, everything punctured in all the tests, right?
No.
The best was a quarter, didn't. I think,
Yes.
correct me if I'm wrong, I thought the record was with a 9/16 inch, that was single wall, but still, there was a quarter of them were punctured.
Yes, 8 out of 32 punctured, and that was at 42 miles per hour in a flat field. And the
So
Remember,
so
it's-
there's nothing in the record of something not puncturing at 9/16 of an inch.
correct at 50 miles per hour. And it's almost 42 to 50 miles per hour is almost 20% faster. And because energy is the square of speed, you're talking about an almost 45%, increase in energy if you're talking about 50 miles per hour, which only applies if there's, as a voluntary speed limit, if there's 20 or more LNG tank cars in a row or 35 or more throughout the consist.
So I had a question about this because it just seemed to me, and correct me if I'm wrong, that this seems to be sort of an unprecedented amount of hazardous material that is being contemplated to be moved by rail. Because like the ethylene, it was 2 or 3 cars. Here, there's like a permit for something like 80 cars. And then there's, I guess, a statement in your brief that 22 cars would be like a Hiroshima bomb if it ignited. So is it, my perception is there hasn't been anything like this before, where we're talking about 80 cars of liquid LNG, I guess 4 Hiroshima bombs almost, being transported together. And then the risk of derailment, you can't say that that's speculative or remote because derailments happen.
Absolutely correct on all scores, Your Honor. That's absolutely right. This hasn't been done. Ethylene is the closest comparable cryogenic fossil fuel that's been transported. There's years with no Weibull data. It doesn't, it's 1 to 3 tank cars at a time. The entire existing fleet of DOT-113 tank cars, which encompasses of the C-120Ws, which transport things other than ethylene too, was 67 at the time of the rulemaking.
And there's no limit on the number of cars you can string together?
Correct.
That just seems extraordinary.
It is, and could have catastrophic consequences if there is a derailment and there is breach. And certainly at the speed we're talking about, there would be breach and possibly catastrophic consequences as a result.
Can you just remind me, are you supposed to be doing the arbitrary and capricious argument too? Or I can't remember the breakdown of who's doing it.
On the HMTA and APA, yes, I'm also doing that. Although, I mean, the states join in that, and I'm sure they will also have things to say on that argument as well.
Thank you very much.
Thank you, Your
Is
Honors.
everybody planning to do rebuttal too?
I don't believe the states are planning to do rebuttal.
Okay, so you and the tribe will do rebuttal.
Yes,
Thank you.
thank you.
Good morning, Your Honors. May it please the court. Brian Lusignan with the New York State Office of the Attorney General, representing 14 states and the District of Columbia. I plan to focus my argument on why PHMSA's analysis of the safety risks posed by transporting LNG by rail violated NEPA, although I think these issues are also relevant to the HMTA violations. First, PHMSA was required to prepare an environmental impact statement because transporting LNG by rail presents unique safety risks that are highly uncertain, highly controversial, and potentially catastrophic. And second, the environmental assessment PHMSA did prepare is arbitrary and capricious because the agency failed to grapple with the central safety issue of what will happen to 50 to 100 tank cars filled with LNG in derailment conditions. When PHMSA suspended the rule, it candidly acknowledged the many uncertainties underlying the rule, but failed to take the logical next step of repealing the rule in full. This court should vacate the rule so that it does not spring back into effect in July of 2025, and so PHMSA can write on a blank slate when it proposes a replacement regulation. With respect to the requirement for an environmental impact statement, this rule poses unique safety risks that are highly uncertain and highly controversial and implicate at least 3 of the intensity factors that require an EIS. Implicating any one of these factors may be sufficient.
Where do those factors come from?
The Council for Environmental Quality has regulations defining when.
Where does the Council on Environmental Quality get the authority to issue binding regulations?
I'm not sure the answer to that question, Your Honor. These are the regulations.
You know that there's at least 4 opinions of our court, maybe more, that question whether CEQ has any regulatory authority because the statute, the NEPA statute doesn't give it to them. It was Jimmy Carter in an executive order did it. And the question is whether that violates the separation of powers. Are you familiar with those cases?
I'm not familiar with those cases, Your Honor. I apologize. I do know this court in the Standing Rock Sioux
Does our
tribe.
argument depend on the CEQ regulations?
No, Your Honor. You can go back to the statute if you want. It requires an environmental.
Factors. There's not 10 factors in the statute, is it?
The NEPA requires an environmental impact statement for major federal actions that may have a significant environmental impact.
That's significantly, Right.
significantly, and the CEQ regulations
CEQ
define
was
significantly.
Out a little bit.
And even if you just want to look at the statute, I think transporting LNG in these tank cars, 50 to 100 together, poses a significant risk of danger. PIMSA itself has acknowledged many times the dangers posed by transporting LNG by rail. In the rule, it recognized that release and ignition of an LNG vapor cloud poses a, quote, serious threat, end quote, to people nearby.
So this could be framed as violating the statute and the case law that says the agency has to take a hard look at the problem.
Correct, Your Honor.
So we could just not rely on the CEQ regulations and decide it based on the statute and the case law if need be?
That's correct, Your Honor, and can look at both the significance of a release event, an event where there's a derailment and LNG is released into the environment, and the fact that the possibility of that is not remote and speculative. PIMSA concedes that you cannot eliminate entirely the risk of derailments.
What is a hard look?
A hard look requires that the agency recognize, acknowledge the environmental impacts that its actions will have, and fully evaluate them.
Quick glance, is that what it is?
It's more than a quick glance. It's looking at the problem and explaining whether that problem is significant or not significant. That's what you do with the environmental assessment.
That's what's done in every NEPA case, yeah.
Well, not in every NEPA case, because typically for a major nationwide regulation like this, the agency would do a full environmental impact statement. Here, PIMSA didn't even do that. They just did an environmental assessment, which is what the agency is supposed to do to determine whether an EIS is required.
Doesn't our case law say something similar to what the CEQ regulations require? Because it does say, I'm looking at Myersville Citizens versus FERC. It has to show that if there's an impact of true significance, an EIS is unnecessary because changes or safeguards in the project significantly reduce the impact to a minimum. So that sounds very similar to if there's a grave risk, it has to be remote or speculative. It's kind of, it's similar, although not exactly the same. And so I guess the bottom line of your argument is this is a potentially catastrophic event with dire doomsday consequences, and they didn't adequately justify that it's not significant because it's just so unlikely to happen that we don't need an EIS?
That's correct, Your Honor. And I think another relevant case from this court is the New York v. NRC case, where the court said that NRC couldn't just ignore the possibility that the spent nuclear waste will remain on site indefinitely, based on its conclusory statement that there'll be a permanent solution when necessary.
Has DOT disputed the applicability of the CEQ regulatory significance factors in this case, or did they accept them?
DOJ has
accepted. Department, the agency.
Yes, excuse me, yes, DOT has accepted the use of the CEQ regulations in this case. No parties argue that they wouldn't apply.
Raise any argument about them.
That's correct, Your Honor.
Under the regulations, they're not allowed to paraphrase or repeat CEQ regulations. All they can do is supplement them for the purpose of the particular agency involved. And the CEQ regulations say that, do not paraphrase, do not repeat.
That may well be, Your Honor.
It's not may well, that is true.
Okay, very well then, Your Honor. I accept that. And again, I don't think you need to go to those CEQ regulations if Your Honors have concerns with them. I think the statute itself and this court's precedents interpreting statute required an EIS.
Yeah, by the way, the DOT never published any regulations dealing with NEPA. The only thing it did was, I think, in 1979, issued an order, but it's never been published. in the Code of Federal Regulations?
Well, unquestionably, DOT remains subject to the NEPA statute, which requires an environmental impact statement for major federal actions that may have a significant impact on the environment. And this is also a case where a wide range of commenters with specific expertise and knowledge about safety issues urged PHMSA to do more analysis of the safety risks posed by transporting LNG by rail. These commenters included the National Transportation and Safety Board, various state safety agencies, organizations representing first responders, the Puyallup tribe, all urged PHMSA to wait until the crashworthiness of these tank cars could be fully evaluated before finalizing the rule.
What is the harm that your clients allege?
For standing purposes,
Right.
yes, Your Honor. We've alleged 3 forms of harm for standing purposes. Probably the easiest to discuss is the proprietary injury to our financial resources as we have to prepare for the transportation of LNG by rail through our states. There was a special permit issued to a transporter specifically to transport LNG from Pennsylvania to New Jersey. Both of those states are in our coalition. There's also, the record is replete with references to the need to transport natural gas from Pennsylvania and other Midwestern states to New England. All the overland routes for that would pass through New York State.
One of the requirements is that the harm be imminent, right?
Correct, Your Honor.
And there was the government comes back and says, number one, this regulation is not going into effect until next June. If it ever goes into effect, it might be suspended or replaced. And number two, it would take 5 years to build up a fleet of tank cars sufficient to transport the LNG. So if you add that together, it's like, about 5 3/4 years before anything gets rolled down the tracks. Why is that imminent harm?
Your Honor, I would disagree with that timeline. The suspension rule will expire on its own terms in July 2025 unless PHMSA issues a replacement. Unless PHMSA finalizes a replacement rule. PHMSA has not yet even proposed a replacement rule. So it's almost certain to expire in July of 2025. Additionally, PHMSA acknowledges that these W9 tank cars are currently being built, albeit they're being built to transport ethylene. But if you read our declaration from Jim Cable, our standing declaration, those tank cars can be converted to transport LNG in a matter of months. So if this rule
be converted, but then you need the equipment that does the freezing, right? What does it take to construct that?
You would need a liquefaction facility. I'm not familiar with the technicalities of how those are constructed. PHMSA recognizes there's at least one of them currently capable of loading LNG into tank cars.
Aren't there already permits? I thought one was, oh, yeah.
Yes, there was a special permit issued for, so there are a couple different permits related here. There was a special permit to transport LNG in these 113C, 120W tank cars issued to a company transporting it from Pennsylvania to New Jersey. There are also 2 permits for transport of LNG in these portable tanks that you can put on a flatbed rail car, one in Alaska and one in Florida. So that's a slightly different issue.
But that assumes liquefaction can occur.
Right, exactly. They are
Is occurring.
capable
Is
of filling
occurring.
these tanks with
Yes.
LNG at this point.
Yes.
I see that I'm out of time. Unless your honors have further questions, I'd rest on our briefs for the remaining issues. Thank you.
Good morning, Your Honors. Aaron Renshie for the Puyallup Tribe of Indians. The Puyallup Tribe became involved in this litigation for the main reason being that it only has one reservation, and it's not going to be getting another one. protecting its homeland is of paramount importance to the tribe, and the tribe has grave concerns about the implications of this rule. The tribe notified the agency about those concerns, and the agency treated those concerns like a check the box exercise.
Could you address the tribe's standing? Because it seems to me, and correct me if I'm wrong, that you're relying on the theory that LNG will be transported by rail from the Tacoma LNG facility, but it doesn't seem like there are any plans to do that. There doesn't seem to be anything connecting the rail spur there to a railroad track.
So first of all, I would say that we're not relying on that in terms of standing. I think that is obviously significant for the disparate impact analysis that we raised in our briefing. But in terms of standing, this rule does not have any restrictions on where these trains with their unlimited numbers of cars full of LNG can go. And
I'm sorry, don't they have to go near the tribe's land in order for the tribe to have standing? Otherwise, they're not
No.
affected.
Yeah, and nothing in this rule would prevent these trains from going through there. I think it's through the tribe's land. Nothing in the rule restricts where the trains can go. Now, understand the risk of them going through the land is much greater if it's being transported from Tacoma LNG. And there's certainly evidence.
But then anybody would have standing that's near a railroad track in that theory, right?
Right, and I would.
If your theory is nothing would stop a train from using railroad tracks near us, then every party or entity that's near a railroad track would have standing. That can't be right, can it?
I think it could be because if the standard is, well, you have to show that this harm is, and I know Judge Randolph used the word imminent, but I think that word has to be relative. There's no time limit or restriction on this rule. The AAR, when it requested this rule, specifically said this rule is likely to, if approved, is likely to increase the interest in transportation of LNG by rail.
That wasn't imminent's not my word.
No, I understand.
Every recitation of
No.
what standing requires for the last 40 years is.
No, I certainly agree, but I'm just saying that we need to understand what the word imminent means, because we have a 30-day deadline, or maybe it was 60 days, to file a challenge to this rule. And if the standard is, if the definition of imminent is, it's going to take several years to get these fleets prepared and going, and therefore it's not imminent, then nobody has standing to challenge the rule within 60 days.
I'm not as
dealt with that problem recently. Supreme Court just took care of that problem recently. If you're not affected at the time, but you're affected later, you can challenge later.
And also my issue is the geographic nexus. I think there has to be some geographic nexus for this type of harm, doesn't there?
Yeah, I mean,
said that before.
Right, and so I mean we have the Tacoma LNG. If we want to talk about the Tacoma LNG facility, certainly we put evidence in the record that the owners of the Tacoma LNG facility have promoted their access to the rail lines, the rail spur that is at the site, as a competitive advantage. Which clearly says that this is an anticipated end use of this facility.
The LNG facility near the tribal's reservation boundaries, there is one, is that?
It is on the reservation boundary.
Trucking? Is it operational?
It is operational.
And so it's used for trucking?
It does, I believe it ships.
Not ships.
It is ships.
Its primary use is to fuel ships, Your Honor. But it also.
From trucks?
No. It's by a pipeline that goes from the facility to the docks. It's at the port. It's in the port of Tacoma.
Now, you also have a consultation claim.
We do indeed have a
Procedural
consultation.
claim.
Yeah.
And you assert statutory and regulatory executive order rights to consultation, that procedural
Right.
injury. And you're saying it didn't happen. That's the issue in the case, but that is a distinct injury as well.
Well, yes, I would agree that it's similar to the Eagle County case that this court cited in terms of the potential harms to the tribe, the risks of derailments and safety risks that this court found sufficient to support standing in that case. And And the procedural harm being the failure to consult with the tribe about this, as well as the failure to conduct a proper environmental justice analysis, which is also a procedural harm. The consultation claim, the National Historic Preservation Act requires the agency to impose an affirmative obligation on all federal agencies to consult with any Indian tribe that attaches cultural or religious significance to property that may be affected by a federal undertaking. PHMSA has not disputed that.
I have not looked at that statute in years. But I know at one point it was considered not judicially enforceable. Is it?
I'm not aware of that. We've had cases, including from this court as recently. I think United Quito was in 2019 that applied the Section 106 of the NHPA. In any event, PHMSA has not disputed that the rule at issue was a federal undertaking, and PHMSA did not comply with its obligation.
How did its repeated outreach to the tribe, emails, phone calls, what is your best case for that was not sufficient effort to consult?
Well, I mean, if the question is whether a handful of emails and phone calls over a period of a few weeks, what's our case for that
Maybe
being
that's the question.
insufficient?
What is your best case that is not sufficient outreach to the tribe?
Every single consultation case cited by any of the parties, whether it held consultation adequate or inadequate, involved much, much more than
That doesn't answer my question as to what is the baseline that the statute requires. There may be others where there were more activities, but here they had the meeting, and I understand your explanation that meeting was cut short. But then after that, there were repeated emails, many unanswered by the tribe, phone calls, efforts to schedule meetings.
Okay.
And I don't know, what is the legal rule that says that's not sufficient efforts to consult?
So first of all, about the meeting, I'll just say it's not just our position that it was cut short.
No,
It's PHMSA's position that it was not,
I
that it was
understand-
focused
I
on
understand
other
all that. I'm trying to
topics.
skip
So,
over
yeah,
that
right.
for sake of
So-
time here, because you wanted to save some time for rebuttal, so I'm trying to
So
save you some time here.
from the regulations and the case law, our view is that there are 4 characteristics of a meaningful consultation. Those characteristics would be a robust exchange of information and views.
They can't do it if you're not answering the emails and the phone calls. They were trying to schedule it. You can't complain about
But
the lack of robust exchange if you didn't respond to their efforts to schedule a meeting.
right, but the meeting they were trying to schedule was not consultation. That what they were trying to schedule was a meeting on very short notice with an
You
agency
didn't have a lot
lawyer.
of time left. I mean, you
Well-
yourselves have said there wasn't a whole lot of time left, and the tribe didn't. In their NPRM, they said, we don't think this implicates a need for tribal consultation. That's public. Tribes were on notice if they disagreed to weigh in sooner. But they provided notice to tribes that they didn't think consultation was required. And it wasn't until very late in the game that the tribe said, we think consultation is required, at least for us, given our situation.
Okay, so let's start with the timing aspect of it, because the NHPA regulations specifically say that tribal consultation needs to occur early in the planning
Yes, but
process.
they said
This
early
was through-
on, they gave notice early on that they weren't aware of a need for it. They can't do tribal consultation if they've made a determination that they aren't aware of a need for it.
But
So
they,
that was public notice.
they also can't throw out their statutory obligation to comply, to consult by simply saying, we don't think there's a need for us to comply, with no analysis in the rule of how
they
they.
knew, how would they have known otherwise?
Well, I mean, I
It can't be
think,
every single thing every agency does. They're going to have to call every single Indian tribe in this country and say, would you like to consult?
I don't know that they need to call. This could certainly send a form letter, if that's the concern.
I'm not aware of any case law that says the NPRM itself, public notice, Federal Register, isn't sufficient.
I mean, there's a case law saying that not beginning consultation until after the notice of proposed rulemaking is insufficient.
If you know that it's going to have implications. I'm dealing with a situation where the agency had come to the reasoned conclusion that it wasn't going to have implications. Maybe they weren't aware of the particular geography of your
Okay,
tribe.
so So I get the court's point. And so the question is, okay, they're sending these emails. All right. Every single case that has addressed this issue has involved consultation that took years, not a few weeks. All those cases involved formal letters from the agencies to the tribes initiating
Maybe how they did
consultation.
it. This time they did it in emails.
Right.
I don't know how I write an opinion that says repeated emails that are not answered by
Okay.
the tribe are
So,
insufficient.
well,
don't
I mean,
understand that.
Repeated emails offering something that is not sufficient consultation would certainly be insufficient.
Mhm.
They're
What's your
off.
best case that meeting with the general counsel is not sufficient consultation?
Well, I mean,
I'm trying to get a framework here. I understand the facts of what you're arguing. I'm trying to get a legal framework that says that their efforts repeatedly to have you meet the general counsel, who is part of the leadership, were, as a matter of law, insufficient consultation.
Okay. Well, I mean, there's a case. There's also
What case?
the Quechon tribe case from the Southern District of California held that the main thing was wrong there. In 2.5 years of meetings
Sorry,
and
you said
letters,
what?
Quechon tribe,
Okay, so the fact that there was a case where there's 2.5 years of meeting doesn't answer my question.
which said
Mhm.
the main thing that case said was the error was the failure to offer the field managers in charge of the case, in charge of the project,
Mhm.
as a consulting
Okay, well, here
party.
you have the general counsel, part of the senior leadership.
Right, I mean, in that case, there were people that were offered who were part of the leadership. It wasn't the decision makers. Here, the issue is, our position is for government to government consultation to be meaningful. It's inherent in that concept that it's with the decision maker.
Is there any, okay. Is there any precedent from our court defining decision maker as you would have it? I don't know who you want, I don't even know from your brief who you think that decision maker should be. Who are you supposed to meet with? The head of PIMSA?
Well, I think it would be up to PHMSA to identify who that
They did,
person would.
identified the general counsel.
No, I don't think no, they never ever claimed that was somebody with decision-making authority. They said that it was they said it was the agency lawyer.
Okay, well, you don't have any idea who you wanted to meet with either? Is that what?
I think the head of PHMSA would be appropriate, but certainly if PHMSA thought that there was somebody with
And what
sufficient.
is your best case that it has to be the head of the agency?
Yeah. So again, I
It's the Southern District of California? Okay.
yeah, yes, I recognize it's a case from the Southern District. We don't have a case from this court. We do have cases from this court saying that there's very little precedent about what meaningful consultation is.
One more sentence, I know, because you want to save some time for rebuttal, and you're already over, but you, go ahead and finish that thought.
Right. So the point I want to make is we do have authority from this case, from this court, acknowledging that once the substantive decision has been made, that is too late for meaningful consultation to occur. And in the email exchanges that we're talking about, the agency admits they are already working to finalize the final.
I understand, but we have precedent from this court that says it's not over essentially till the fat lady sings on the Federal Register.
No, it doesn't say that. It says that would be incorrect because the court is talking about the 8th Circuit case of Oglala Sioux, where it was not a final order issued. When it said that the substantive decision had been made. The final order was issued after the consultation occurred. So,
But if there were precedent from this court saying as long as it happens before the final rule, then that would bind this panel.
I would assume that this court would be required to follow other decisions of this panel. Yes, Your Honor.
Perfect. Thank you. Any other questions? Thank you, Counsel. All right, guess we hear from PIMSA now?
May it please the court, Rebecca Jaffe appearing on behalf of the United States. With me at council table are Charlie Enlow and Sean Ford from the Department of Transportation. In promulgating the rule, PHMSA acted reasonably under the APA's arbitrary and capricious standard and applied its expertise in hazardous materials transportation. The rule rested on top of the existing hazardous materials regulations, a robust set of regulations governing all aspects of hazardous materials transportation. And then for LNG specifically, PHMSA added a number of requirements: an enhanced outer tank, enhanced braking systems, remote location and pressure monitoring, safety and security route planning, among other things. PHMSA reasonably concluded that these additional requirements, plus the existing hazardous materials regulations, would ensure the safe transportation of LNG by rail and prevent any significant impacts.
How does PHMSA know that this is sufficient? Because it just seems that this is sort of an unprecedented amount of hazardous material with exceptional inflammatory properties. It just, the doomsday scenarios are quite dire when we're talking about LNG that can result in a boiling liquid expanding vapor explosion that can leak and then ignite. And there's no limit on the number of rail cars you can string together full of LNG. There's, I guess, they've made the argument that 22 rail cars is the equivalent of the bomb, a Hiroshima bomb. I just find this extraordinary, the risk being so high, and that you think just increasing the thickness of the outer wall would be sufficient to address that risk. Like how do you know that, and what's your basis for saying so?
A couple points, Your Honor. First of all, the hazardous materials regulations, PHMSA in its history has never limited the quantity of hazardous materials that can be transported in a particular train. And there are other flammable hazardous.
There's a permit that asks to string, I guess, 80 of these together. It's a lot of trains. That's almost 4 Hiroshima bombs.
Your Honor, I can't speak to the accuracy of the Hiroshima bomb analogy, but I can say that PHMSA in 2015, for example, promulgated a rule addressing what it calls high hazardous flammable trains. So that's large shipments of crude oil and ethanol. Those shipments often have 70, 80, 100 plus cars in the train. PHMSA has never limited the quantity of hazardous materials that can be on a particular train.
No, I understand. I just think this seems to be unprecedented in what the doomsday scenario would be, because derailments are not remote or speculative. And it just seems that there's this risk of cascading consequences. If you've got a whole bunch of these together and one ignites and they all ignite, and say it's near a city or a populous region, it just seems extraordinarily dangerous.
Your Honor, I beg to differ. PHMSA put a number of safety measures into the rule. There's the enhanced thickness of the outer tank.
No, I understand that. I'm just wondering why that's adequate, and why is it not arbitrary and capricious that you decided that was adequate when there's been no testing?
Well, to the first point, I would just say that's not the only measure in the rule. But to the second point, PHMSA relied.
The other measures are even less convincing. But go ahead.
I think it's the measures combined together that PHMSA were the basis for PHMSA's determination. But PHMSA did rely on modeling done for that 2015 regulation that I mentioned that showed the risks of breaches and punctures were much lower with 9/16 of an inch thick tank shells. It also looked at real world derailment data that showed, comparing 3 derailments where 2 of the derailments involved cars that are 7/16 of an inch thick, and then 1 derailment had cars that were 9/16 of an inch thick. And those cars did much better in the derailment. So
it's lower, but it's still, I guess these particular types of cars that you're proposing have never been tested, and there are no studies where there was no puncture. It just seems potentially catastrophic. And I guess to put this into the legal framework, you're required to do an environmental impact statement if there's a significant risk. And this is a huge risk, and it's not remote or speculative or unlikely to a minimum. You haven't proposed things that make it to a minimum. So whether you look at the CEQ regulations or whether you look at the case law, like why is this not something that requires an environmental impact statement because of the significance and the graveness of the danger involved?
I beg to differ, Your Honor. The agency did propose or require a number of measures to minimize the risks. It also relied on its lengthy history of hazardous materials transportation regulation.
But derailment is a risk, and you can't do anything to, I guess, it's not within your bailiwick to make railroads more safe, but given that derailment is a risk that's not remote or speculative, and the catastrophic consequences of a derailment in this scenario, why is not an environmental impact statement required?
Well, Your Honor, a couple points. First, I think that's part of why, for example, among the measures that PHMSA required in the rule, it required safety and security route planning to make sure that railroads are taking into account various factors such as population density, track profile, sensitive areas nearby. So railroads are required to do that, and they do that. PHMSA also required enhanced braking systems for once there's a certain number of LNG cars in the train. And some uncertainty doesn't mean that an EIS is required. And here,
But it has to be remote or speculative, or it has to be reduced to almost a minimum. Like you just, in your brief, it seems your position is the risks have been lowered, but it hasn't been lowered to the extent that the case law and the regulations, if we rely on them, require.
I disagree, Your Honor. I think PHMSA took a hard look here and it reasonably concluded, based on its expertise in hazardous materials transportation, based on studying past derailments and what happened in those derailments, based on studying 450 incident reports involving releases from DOT 113 cars specifically, based on the measures that it put in this rule.
So the safeguards have to sufficiently reduce the impact to a minimum. You think the risk of a derailment is at a minimum based on what the agency has done?
I think the risk of significant impacts from a derailment has been reduced to a minimum. Yes, Your Honor.
Okay, explain that.
Because PHMSA required the 9/16 of an inch outer shell, which the modeling and data show and the real life derailment analysis show has a reduced risk of punctures. It also, the DOT.
Puncture, if one car gets punctured, is that a significant impact?
Your Honor, it very much depends on the context, but
Well, I'm asking this, you just said we have to reduce significant risk of significant impact from a derailment. You can't stop a derailment, but you, and so then we start talking about punctures. So I'm trying to figure out if one LNG car is punctured, does that count as significant impact? Or do you think there have to be multiple punctures?
I think it would very much depend on the circumstances,
What
which is what.
circumstances? What other circumstance?
Where did the derailment happen? Did the pressure relief devices function as they do in the testing? How quickly did first responders respond? PHMSA also does a lot to make sure first responders know how to handle incidents involving hazardous material. And that's why it required safety and security route planning, so that if any derailments occur, railroads will have considered the potential risks of any given location that they might be transporting.
I guess, I'm trying to interrupt your
No, go
question
ahead.
here, but I'm trying to understand how you could decide it's no significant impact, or it's the minimum possible significant impact from a derailment when you can't, I take it there's no rail path for this LNG that avoids populations altogether, that avoids people altogether, or sensitive environments altogether. Right, there's going to be people along here. We don't know where the derailment's going to happen. If they're avoiding large populous areas, understandable, then they're in rural areas. You can't make every volunteer fire department in every town of 1,000 people be ready to respond to a punctured LNG car, or 2 or 3 or 5 or 100 of them. So I don't understand the analysis. I'm just maybe just elaborating on or giving my own concerns, following up on Judge Pan's question, is just telling me a few technical things that are there doesn't tell me the reality of how this is going to work on the ground.
So if a derailment were to occur,
In a rural area, so it's not a city.
so
It doesn't have, may not even have a professional firefighting department.
So part of the hazardous materials regulations are requirements for hazard communication. So every car carrying hazardous materials has placards denoting what's in it. Railroads also have to have lists of the contents of every car. PHMSA has
How
a
is this any help at all when the derailment occurs in a populous area that has a volunteer fire department?
because the book will say this evacuation distance. For example, for LNG, it's a mile, which is a distance that PHMSA uses for a number of substances. And it says, don't shoot water on it. Use this type of foam. So, and PHMSA also
Does that help
issues.
If these, does every volunteer fire department in every rural area in the country have foam?
That I don't know, Your Honor, but I do know that PHMSA issues grants to help first responders build up their capabilities. But the key thing is containing the scene until the railroads have experts that come in. And I should acknowledge,
Are they on the train already, or how fast do they come in? I don't know where they're based.
I don't know either, Your Honor, but
All this stuff seems like stuff we need to know if you're going to say there's no significant impact from a derailment, where there's a car punctured, or two, or three.
Your Honor, I think PHMSA looked.
I grew up in a small town, so I'm trying to figure out how this is, how they're supposed to respond to this in a timely manner. You don't have days before the harm happens here. You've got, what, maybe minutes or hours?
Well, that's partly why PHMSA required such a robust tanked car here, because that buys time. It reduces the number of punctures. The DOT 113 cars also have redundant pressure relief systems. The pressure relief devices on either side of the car. So even if there is a fire, PHMSA expects that the pressure relief devices will function and any dangerous pressures will be vented.
Are there two different risks here? The pressure relief it guards against the rail car exploding from the buildup of pressure inside, because if the LNG starts, they call it boiling, but it goes above the -260, it starts to become vapor and it builds up pressure and it can explode the car. But the puncture it comes out and then it can be ignited, right? Isn't that the risk? And it can do this like vapor cloud, and all kinds of things can happen once it gets out and there's a puncture. And if it's ignited and there's a car of 22 of these, do the other ones ignite as well? I'm just trying to understand there's a couple different kinds of risks here, and it's just not at all clear to me that the agency has done the work of testing this different scenarios that could occur.
Does pressure relief deal with the leak?
So
I'm just basic question on you.
Yeah, no.
a couple points, Your Honor, and I apologize for being unclear. A pressure relief device is not what's going to prevent a release of hazardous material. I do want to clarify, there's different terminology here. Just because there's a puncture doesn't mean there's a release of hazardous material. You can have a puncture, for example, of the outer shell. That doesn't mean the inner shell got punctured. But going with your hypothetical, assume there is a breach and there's a release of LNG and it does catch on fire, which is 3 ifs all together right there.
But doesn't seem very remote in a derailment.
Your Honor, PHMSA evaluated the risks here. It had.
No, I understand. I just think derailments happen. Sometimes they're quite severe. It's clear that it happens, and sometimes like the trains are wrecked. And so what happens if there's 80 LNG rail cars in a row and one of them, say pressure release doesn't work and it explodes, and I guess it says that happens, you've got a fireball, you've got projectiles, you've got all kinds of stuff. Does the entire train blow?
So
like a Hiroshima bomb?
PHMSA concluded that the pressure relief devices would work because there's redundant. So even if one doesn't work, the other one would. Then let's say there's a fire, going with your example, then the other cars, let's say another car heats up, then its pressure relief devices will work. And again, we have the robust outer tanks, and these are the 113 cars.
The tanks are breached. I just want to make sure I understand this engineering question. They're breached. If the inner tank is breached, pressure release is no help because you've got a hole and the stuff's coming out, right?
Yes, Your Honor.
If the inner tank's breached, we've got to assume the outer tank is breached.
Yes, Your Honor, and that is true. If the inner tank's breached, the outer tank will. I'm sorry, I'm trying to respond to the question of if one car breaches, how would that affect other unbreached cars?
Mhm.
And for those cars, if they're exposed to fire, then they would vent.
Mhm.
And
What are they venting? Are they releasing LNG into the air, or what are they venting?
Yes, yeah, they would be venting LNG vapor.
I think I read someplace that if they turn upside down, the vent system doesn't work.
PHMSA, I believe at JA 459 has a footnote that says even if they're upside down, the way the pipes work, they'll still vent.
But did PHMSA determine with 100% certainty that the pressure release systems always work in a derailment?
I'm not aware that it reached 100% certainty, no, Your Honor. But it did examine every incident report it had for a DOT 113 car ever since those have been in operation. And that's over 50 years, 100,000 trips transporting hazardous material in the 113 cars.
The NTSB said that what you did was not adequate.
The NTSB recommended that PHMSA adopt certain operational controls, and it did follow the NTSB's recommendations. I mean, in rulemakings, the agency's not necessarily
Said
going
more
to.
than that, though. Said that it was not a effective safety evaluation.
Your Honor, there's a range of comments that come in on any given rulemaking, and PHMSA responded to the NTSB's comments, and the NTSB made some suggestions that PHMSA thought were reasonable, and it adopted them.
Is the venting, is there any risk from the vented LNG vapor? Health risk if you had, say, 80 cars of LNG on a train and they all had to start venting? Is there any risk from that? Or is it only if it's actually?
I suppose there could be risk. It could be the PHMSA's emergency response guidebook that it publishes that gives information about how to deal with each hazardous material does describe, you know, if there's vapor, you need certain personal protective equipment. So I can't say that venting LNG is reducing the risk to zero. But
if the pressure release system itself creates a hazard for people in the area and you're going to have 80 or 100 of these cars, and let's assume any, 20 or 30 of them, because of the derailment, are all venting at the same time, does that create its own safety hazard? And if
so, LNG will, excuse me.
So where did PHMSA address it?
I'm sorry, would you mind saying that?
If you have multiple cars, the large numbers that are authorized here, venting at the same time and in the same area, does that create its own health issue?
No, Your Honor.
But the environmental assessment said that venting LNG can catch fire. There was an incident in the environmental assessment.
Yeah, yes, it can. It can. What I'm saying to the health issue is in the air, LNG will eventually dissipate. And so, and part of PHMSA's.
Eventually, but.
And PHMSA in the guidebook recommends a 1 mile evacuation distance for LNG. So
The venting starts right away from the derailment. If the pressure goes up, it's going to start pretty fast.
I mean, it would depend on the.
It must take some time to evacuate a community a mile away.
I mean, how quickly the venting would start, I think, would depend on the circumstances of the derailment, and the time it would take to do an evacuation would also depend, I think, Your Honor.
And which one is on the prior transportation of things, I guess ethylene is the one that the agency thought was most similar. Is my understanding correct that there isn't a history of having 10, even 10, let alone 100 ethylene cars in a single train? That it was only a couple at a time?
That is correct for ethylene, which is similar as a cryogenic flammable liquid to LNG, but PHMSA also has experience with high hazard flammable trains like crude oil and ethanol, and those are transported in quantities of 80, 100 or more.
So this was the comment from the NTSB, because unit trains of DOT 113 tank cars carrying large volumes of flammable cryogenic gases have no operational or accident performance safety history. We believe a thorough safety assessment of the tank car specification is needed. There's no history of doing what this rule allows.
There's no history of unit trains, which are trains carrying all of one thing, large numbers with DOT 113 cars. But PHMSA looked at a number of sources for its conclusions in this rule. It looked at the history of 113 cars, which is what you need for a cryogenic liquid. It also looked at the history of unit train transportation of flammable liquids like crude oil and
That's
ethanol.
totally different. You have a derailment with crude oil is very different from a derailment with LNG.
There certainly are differences, Your Honor, but I think that's where PHMSA's expertise really comes in to say, here's what makes sense to.
On your expertise, I want to throw one more mix into the factor here. No speed limit. No speed limit. I mean, you talk about there's a voluntary standard by the American Association of Railroads, American Railroad Association. Is every railroad that's going to transport LNG required to be a member of that association?
That I don't know, Your Honor, but I do know
That's
that.
not in the rule. Doesn't the rule requires you to be a member? I don't, maybe every train is already a member? I don't know.
To my understanding is that PHMSA, that all railroads have incorporated the industry guidance, industry requirements for best practices into their operating rules, and PHMSA and the Federal Railroad Administration are not aware of railroads not complying with it.
I'd like to ask you a question on a somewhat different topic. 2 years ago, or no, a year ago, was it 22 or 23? You filed a document in this court opposing the lifting of the abeyance that the court had issued. You remember that?
Yes, Your Honor.
And you made representations in that document about the ongoing activities of this particular administration aimed at amending the rule that we're now arguing about.
Yes, Your Honor.
And you also said that imminently or soon that another abeyance regulation would be issued. You remember that?
I'm not sure the adverb that I used, Your Honor, but
I just
PHMSA.
looked at it, trust me. But what is going on now with you say in your brief that there's all kinds of studies that have been done. There's a joint task force that's been put together. You said that back whenever this was, let me get the date straight. This was a year ago in June. You said that the agency was contemplating two rulemakings. One is to amend the rule that we're talking about here, right? And the other was another suspension. So what has happened? What is going on now?
The rule is currently suspended. The PHMSA suspended the rule in September of 2023, and it's suspended through June of 2025. So before the suspension happened, nobody had transported LNG by rail under the rule. Now nobody can because the rule is suspended through June 2025. PHMSA has also been doing a number of tests and it is planning to use to inform a subsequent rulemaking that would amend this rule or revise it in some way or consider doing so. And in the spring 2024 Unified Regulatory Agenda, PHMSA said that it anticipated doing a notice of proposed rulemaking.
Has something been submitted to OMB?
No, Your Honor.
So you anticipate doing an NPRM when?
The spring 2024 Unified Regulatory Agenda said April 2025.
Okay, so there's no way you're going to have a final rule by June 25 when the suspension ends.
That may be unlikely, Your Honor, although PHMSA could decide to extend the suspension. It hasn't made any final decisions in any direction on these.
Do you know whether there's any further suspension regulation in the works?
I don't think PHMSA is currently working on one, but it may choose to do so between now and June.
Is this rule on a list that was submitted pursuant to the executive order to submit it to IRA? There was.
When President Biden took office, Your Honor?
Yeah, which required examination of every regulation that was issued during the Trump administration that affects the environment.
Yes, Your Honor, this
So
was,
It was on the list.
to be very precise, Your Honor, it wasn't named in the executive order, but it was on the White House list of rules that needed to be considered under the executive order.
Is there any official agency pronouncement indicating that this rule needs to be amended?
PHMSA has not reached any final conclusions, Your Honor, about whether it's going to amend the rule in some way or take some other action.
Well, let me rephrase the question, that whether this rule is going to be amended or repealed.
PHMSA has not reached any final conclusions on that, Your Honor.
And the representations that we see from counsel that sort of hint at that are not approved by the administration? Not the Biden administration, the administration, the Hazardous Materials Administration.
Your Honor, PHMSA has reviewed every filing that we've submitted in court. And it has published in the Unified Regulatory Agenda anticipated timing for what we've been calling the amendment rule. The timing for the anticipated timing for the notice of proposed rulemaking for the amendment rule has shifted back several times.
Has it shifted since that last pronouncement?
So I'm asking these questions because I think there's a substantial question whether this case is ripe. And there's a Supreme Court case called EPA versus Brown that indicated when the attorney for EPA got up and argued before the Supreme Court and then said that the regulation in front of the court was going to be amended, had to be amended. The Supreme Court then vacated the lower court's decisions pending the outcome of that proceeding. And if we're not there with this rule, it seems to me, given the representations that have been made, we're awfully close. And there is a timing question, I agree, but we're going ahead and deciding the validity of a rule which may never go into effect practically.
That may be true, Your Honor. I don't know when any final amendment rule would issue if PHMSA has not yet made any final.
Speaking for myself, and I haven't consulted with my colleagues here, I would like to see a representation in writing from you on behalf of that agency with respect to the timing of any possible new suspension regulation or a notice of proposed rulemaking. And if there is no such schedule, I'd like that to be stated in the filing too.
Yes, Your Honor.
Thank you.
I will do that.
I forget where we were, but I think. I'm just still concerned about the speed limit. If we don't know that all trains are members, or if, even if they are all members, all it requires is voluntary compliance and the rationale being that gives the industry flexibility to respond more quickly if new technology comes along. So, there's no speed limit. There's no speed limit. It's like if they said on the Beltway here, 55, but it's voluntary. There's no enforced speed limit for these trains of 80 to 100 LNG cars. And I just didn't see that. The assumption that, well, we're trusting that everybody will comply seems to me, I think you have to factor in your testing. What are the prospects of somebody violating the 55-mile-per-hour rule?
And to add to that, there was an accident at 42 miles per hour where there was puncture with 9/16 of an inch cars.
Your Honor, PHMSA and the Federal Railroad Administration, they are not aware of any instances of railroads not complying with their operating.
Do railroads have to comply when they violate it's not even a violation, it's voluntary. They have to report their speeds to this association or to FRA or PHMSA or?
I'm not aware that railroads have to report their speeds all the time. A lot of the speeds are programmed into the trains. A lot of trains have PTC, I think it's positive train control, programmed in, and so they program it in.
A lot of trains, does that mean all trains that would carry LNG?
I don't know, Your Honor. I think it's the most trains on major tracks by major railroads, which have.
Those are the ones that carry LNG. I don't know if it's, this seems to me a big hole, a big problem. That if there's actually no enforceable speed limit, and you say we don't know about violations, well, I'm assuming people don't voluntarily report when they go over a speed limit, let alone a voluntary speed limit. But what's to report? It was voluntary.
Well, railroads do have to comply with their operating rules. I should also note that railroads have their own speed limits related to the particular tracks and the track profile that they're
Do
in.
any of those go over 55 miles per hour?
To my knowledge, Your Honor, the fastest any freight train could go would be 70 miles per hour, but that would not be if it had 20 cars of hazardous material or one
What if
car.
it had even one car of hazardous material?
If it had one car of spent nuclear fuel or poisonous by inhalation.
I'm asking if it would one car of LNG or two.
It would depend on the track
So
locations.
they could go more than 55.
It would depend on it is possible, Your Honor. It would depend on the track location and the railroad's security and safety route planning, their analysis of the track profile, all of those things.
The cross your fingers and hope rule.
I beg to differ, Your Honor. I think
Is there
PHMSA,
uncertainty as to what speed these trains are going to travel for purposes of whether an EIS is needed? And what the impact of given higher speeds, frequency and impact of higher speeds would be?
PHMSA did not believe that there was any
On what
uncertainty.
basis? Could you tell me you don't know if all trains are even part of this association? So those trains won't even be subject to this voluntary standard. We don't have any idea how many comply with this voluntary standard. We don't know how many have it programmed in speed control and what that speed control is, because apparently on some tracks it could be 70 miles per hour. But that seems like a lot of unknowns. That seem quite relevant to what I assume the speed of trains is a factor in increasing the risk of derailment. Is that wrong as a matter of physics?
I cannot say the court is wrong. No.
I haven't had physics since high school, so you could say I'm wrong and I would have to defer. But, okay.
Well,
So,
can I just add to that, though? Does the agency have some kind of an obligation to make sure this 50 miles per hour is appropriate for this kind of hazardous material, given the sort of unprecedented sort of danger that is posed by like an 80 car train full of LNG using a tank car that's never been tested for safety before? Can the agency just default to 50 miles per hour without looking to see if this voluntary standard is even the correct one for this type of transport?
So even setting aside the fact that, to the best of PHMSA's knowledge, railroads are complying with it, but even setting that aside, Your Honor, 50 miles per hour is also the standard, the speed limit that PHMSA does mandate for poisonous by inhalation, for trains carrying hazardous materials that are poisonous by inhalation. It's also the speed limit mandated for the high hazard flammable trains, the ones with 8,100 cars of crude oil or ethanol.
Yeah, I guess my question is just that, can you assume that that's the right level for this sort of previously unknown situation where we could have like an 80 to 100 car train full of LNG with the risks that we've been discussing this morning? Is it okay, or is it arbitrary and capricious to assume that?
I think PHMSA acted reasonably here in evaluating
But did they evaluate like this particular substance versus the others? In terms of the I guess the speed that would be safe to transport it?
Not to my knowledge, Your Honor, but I also should note that PHMSA here was saying.
But so why is that reasonable?
Because, Your Honor, of PHMSA's long expertise in the field of hazardous materials regulation. And
They
it's,
didn't exercise expertise if they didn't even compare it. It doesn't sound like they even thought about it, that this particular substance could be different from the others.
well, PHMSA thought very hard about LNG as compared to other materials. So I apologize if I've communicated otherwise, but it compared,
But in terms of the safety of the speed with which you transport it, they didn't consider that, did they?
not
It just
that,
seems to me a risk of derailment of the 80-car LNG thing is very different from the 2 or 3-car ethylene car. It's like a completely different thing. So maybe you want to go a little bit slower if you've got the 80 cars of LNG.
well, so there then the comparison for PHMSA was the crude oil or ethanol trains that
They're not Hiroshima bombs.
I can't speak to the accuracy of the Hiroshima bomb
And you said,
analogy.
just to pin one thing down, you said PHMSA, to the best of its knowledge, thought folks would comply with its 50-mile-per-hour speed limit. And what I want to understand is, what was the knowledge that was the best of their knowledge? What information did they have, other than that? What I'm aware of, and you can supplement, is that this association has a voluntary standard for its members of, sorry, it's a 50 or 55 miles per hour. And that
50, Your Honor.
right, 50 miles per hour. What other knowledge did you have?
PHMSA worked on this rule with the Federal Railroad Administration, which regularly reviews railroads, and the industry practice requirements, the document called OT 55, which is what specifies the 50-mile-per-hour limit, is incorporated into railroad operating rules.
Didn't
And
the
It's incorporated as a
NTSB
voluntary or mandatory?
Railroads have to comply with their operating rules, and PHMSA and the Federal
Their
Railroad.
operating rules are, there's a voluntary limit. So there's two ways of incorporation. It's, you could take some of this voluntary, incorporate it as mandatory, 55 or 50-mile-an-hour cap, full stop. Or it could be, as part of your operating rules, there's a voluntary limit of 50 miles per hour. And so it's, if you incorporate it as voluntary, you just haven't changed anything, in my view.
Your Honor, the industry guidance document, OT 55, says that if there are, for key trains, which is trains with 20 or more cars for LNG, it's, if you just need one of spent nuclear fuel or poisonous by inhalation, but a key train for LNG would be 20. The maximum speed is 50 miles per hour.
Now, didn't NTSB want that capped at 40 in high threat areas?
The NTSB may have made that suggestion, but that isn't.
Did the agency address that comment? And why that they didn't need to do that?
I'm not sure, Your Honor.
Any other question? Right. Thank you very much. Or did you want to have a wrap-up sentence here? But otherwise, I will echo Judge Randolph's request for this information about whether we should even be deciding this case.
Yes, Your Honor, we will file something in writing. I just wanted to note a sensitivity. If the court is inclined to rule against the United States, PHMSA has in the past had to require a particular packaging that has never been tested or built before because it knew that packaging was safer than what was already in use. And if the court issues a ruling that requires certain amounts of testing or data before a packaging can be allowed under the Hazardous Materials Transportation Act, that could have negative consequences for PHMSA's very important safety mission.
It's important. Thank you.
Thank you.
Okay, Mr. Marshall, we'll give you 2 minutes.
Thank you, Your Honor. For the voluntary speed limit to even apply, it doesn't apply if you have 19 of these LNG tank cars in a row or 34 spread throughout the consist. In that case, there's not even a voluntary speed limit. It only applies if there's 20 in a row or 35 spread throughout the consist. On the route planning requirements, there's no binding requirements to not go in any specific places. It's an analysis, it's a consideration. You can still go through urban areas after you do that analysis. And so you could still have LNG unit trains going through major urban areas under this rule. Regarding pressure release devices, they will only work if they're upright. It's in the record, if you look at Joint Appendix 427, that if a tank car gets overturned on its side or whatever, which often happens in derailments, they do not work. It requires that they be upright. The reference to JA 459 doesn't say anything about them working if the tank car is overturned. It refers to the complicated, slightly more complicated nature of the pressure release devices of the DOT 113 tank car and regarding to the fittings and the risk of liquid leak. It does not address or even hint that pressure release devices will work if they are overturned.
Can I ask you just one more thing? When do you think this is first going, when do you think this first shipment of LNG in one of these new cars could happen? Assuming they don't suspend it and don't amend it.
After the rule springs back into effect in 2025, we know from
Are
PHMSA
there,
and,
there's tanks built, these new cars are already built.
well, yes, we know that they're being built. I mean, as PHMSA said,
Being built is different than.
yes, they've been built. Yes, they have been built.
They're sitting out there-
PHMSA
They're sitting out there on the sale lot.
PHMSA believes that they have been built for ethylene and that they know that there was interest in other orders. That was of 2023.
Mhm.
There's nothing in the record since then about how many have actually been constructed since then and how many are available to ship LNG. But we know that we know that Energy Transport Solutions intends to use it. Their new special permit to use the existing DOT 113 tank car was denied. And so they said that they have to rely under this rule.
And when does that start under are they having to use it right now then? Or when does their new permit?
No, it's expired. So they can't use the special permit to transport LNG under the DOT 113 existing
right.
tank cars.
And do they have a permit to do it under this new tank car? And are they doing it?
Well, they wouldn't need a permit because there's no permits required under this
Well,
rule.
until 2025.
Right, okay, yes, no, they're not doing it. I understand your question now, Your Honor, I apologize. There is no special permit to use this tank car
Right now.
right now
Even now.
for Energy Transport Solutions.
Any other questions?
Thank you, Your Honor.
All right, Mr. Renshie, we'll give you the same 2 minutes.
Thank you, Your Honor. The NHPA regulations are clear that Indian tribes get special treatment in the consultation analysis. Section 800.2 says that the federal government has a unique legal relationship with Indian tribes, that consultation with Indian tribes should be conducted in a sensitive manner, respectful of tribal sovereignty. Consultation with an Indian tribe must recognize the government-to-government relationship between the federal government and Indian tribes, and consultation with Indian tribes should be conducted in a manner sensitive to the concerns and needs of the Indian tribe. What happened here, a handful of emails sent over a few weeks offering an agency lawyer with no decision-making authority, while 3 years into the rulemaking proceeding, a few months before the final rule was published, did not comply with the standards there. And the last point I want to make is I talked about sending letters and how in all of these other cases, letters were sent. And Judge Millett, you asked me, what are they supposed to do if they're sending emails that aren't being responded to? They could have done what happened in every one of these other cases, which is if the staff level employee who was offering the agency lawyer for consultation didn't think his emails were being responded to fast enough, the agency could have sent a letter to the tribe formally invoking consultation. That should have happened.
Is the
More
problem
was
that the tribe
required.
isn't getting the emails? Does the tribe deny that it got the emails?
No, the tribe is not denying that it got the emails. We're saying that this was not, sending a few emails over a few weeks is not conducting consultation in a manner respectful of tribal sovereignty and recognizing the special relationship between two sovereigns.
Thank you very much. This case is submitted.
The Honorable Court now stands adjourned for Monday, 30 a.m.